Thank you very much, Mr. Speaker. Bill C-22, the so-called Lawful Access Act, is being presented as a necessary modernization of investigative powers in the digital age. And to be clear, there is some truth in that framing. We do need to modernize. Law enforcement and national security agencies are operating in a rapidly evolving technology-driven environment. Serious crimes from human trafficking to foreign interference are increasingly digital, distributed, and difficult to detect. Human trafficking networks now rely on encrypted messaging, anonymous accounts, and constantly shifting online identities. Foreign interference operations depend on coordinated digital campaigns, pseudo-anonymous actors, and infrastructure that crosses borders in seconds. In both cases, the central challenge is attribution, identifying who is behind an account or activity quickly enough to act. Parliamentary findings have confirmed that agencies like the RCMP and CSIS face real difficulties accessing communications data, and that without some form of data retention, information sought under warrant may no longer exist. So the problem is real. The need for tools is real. And New Democrats recognize that law enforcement must have the ability to investigate serious crimes and protect public safety, whether that is child exploitation, human trafficking, terrorist threats, or foreign interference. But those powers must always be balanced with strong protections for privacy, civil liberties, cybersecurity, and meaningful consultation. That is the test before us. Before, we have also seen what happens when the balance is lost. The government's previous attempt under Bill C-2, the so-called Safe Borders Act, an omnibus bill, was widely rejected by over 300 organizations and tens and thousands of Canadians because it was an attack on civil liberties, on privacy rights, on due process, and the rights of asylum seekers. C-2 has now come back in different parts. The attack for asylum seekers lives on under Bill C-12, and the NDP vehemently opposed Bill C-12. The parts about lawful access continues in Bill C-22, and I would say it does include some improvements. The removal of blanket warrantless information demand powers matters. Replacing that with a more limited confirmation of service tool based on reasonable grounds and restricted to a yes-no response is a step in the right direction. Judicial authorization remains required for further access, which is essential. So yes, there has been some movement. But we should also be clear about what this legislation does. This is not simply a modest update. It is a significant restructuring on how the state, private companies, and individuals interact in the digital space. And there are serious concerns, particularly in Part 2 of this bill. Part 2 would require electronic service providers to build and maintain interception capacities within their systems, and it introduces the possibility of mandatory metadata retention, potentially requiring the storage of location data, device identifiers, and communication metadata on all users for extended periods. It would allow the government to require companies to retain metadata for up to 1 year. Metadata may not include the content of communications, but it reveals patterns of behavior, who we talk to, when we talk to them, where we are, and how often we interact, and for how long. In the digital era, metadata is often more revealing than content. It is a skeleton of a person's private life. And under this bill, that data can be retained not because it is needed for a specific investigation, but because it might become useful in the future. This is a profound inversion of privacy law. It replaces targeted suspicion with generalized collection. And in addition, the Minister of Public Safety is granted authority to issue secret orders requiring providers to modify their systems to facilitate access to user information. These orders do not require judicial authorization, they are not subject to public scrutiny, and in many cases, they may never be disclosed. Instead, they are approved through an administrative process involving the Intelligence Commissioner. Now, while that office plays an important role in oversight, it is not equivalent to independent judicial authorization in open court. We're told this is necessary to ensure that data exists when investigators need it to reconstruct networks, identify victims, or attribute foreign interference. Those are legitimate objectives, but the question is not whether those objectives matter. The question is whether the approach is proportionate. Bulk, indiscriminate data retention risks treating every Canadian as a potential suspect rather than focusing on targeted investigations. Metadata is not benign. It can review deeply personal information, patterns of movement, association, and behavior. Mandating its large-scale retention also creates cybersecurity risks. Concentrating secret, sensitive data makes systems more vulnerable to breaches, to misuse, and to exploitation by malicious actors. And we should be cautious about requiring companies to build surveillance capabilities into their systems. Even where the intention is lawful access, these kinds of systemic access points can introduce vulnerabilities. And experts have repeatedly warned there is no such thing as a perfectly secure backdoor, only works for one purpose. It exists for everyone. The committee report on lawful access is instructive here. It acknowledges the operational challenges, gaps in data availability, coordination issues, and the need for lawful intercept capability. But it also makes clear that any framework must be grounded in necessity, proportionality, and legitimacy. It found no support for requiring backdoors to encryption. It highlighted a lack of clarity in the government's overall approach, and it raised concerns about the absence of a coherent, transparent strategy. That raises another important question. Why was there no more meaningful consultation with the Privacy Commissioner and an independent officer tasked with safeguarding the rights of Canadians? At a time when trust in digital governance is already fragile, that omission matters. We should also look internationally. Broad data retention regimes have faced legal challenges in other jurisdictions. More targeted alternatives, such as quick freeze models, have been explored, preserving data tied to specific investigations rather than requiring ongoing generalized collection. So again, the issue is not whether tools are needed. In fast-moving cases, whether it is locating a trafficking victim or identifying a coordinated foreign interference network, timely access to data can make a real difference. The issue is whether, though, this bill strikes the right balance between effectiveness and rights. Does it provide law enforcement with the tools they need without overreaching? Does it maintain robust judicial oversight? Does it avoid creating systemic cybersecurity risks? Does it respect the Charter principles of necessity and proportionality? And more importantly, will it withstand constitutional scrutiny? Because if that balance is not right, the consequences are not just legal, they are democratic. Privacy is not an abstract concept. It is what allows people to speak freely, organize, and participate in public life without fear of constant monitoring. When surveillance becomes more expansive and less constrained, it has a chilling effect, and that is well documented. So the question before us is not whether we act, it is how we act. Bill C-22 reflects an attempt to respond to real and evolving threats. It includes improvements over what came before, but it also raises serious, unresolved questions, particularly around the scope of data retention, the role of executive authority, the risks of cybersecurity, and the adequacy of oversight. Those are questions this House must examine carefully before effective policing intelligence work can and should operate within robust legal frameworks that preserve judicial oversight and limit data collection to what is strictly necessary. Because getting this wrong would not just impact investigations, it would reshape the relationship between Canadians and the state in the digital age. Advocates for civil liberties and privacy have very real civil liberties concerns that Bill C-22 represents one of the most serious proposed threats to privacy rights in Canada in the past 2 decades. And that is not something we should do lightly, because our civil liberties is the cornerstone of our democracy, Mr. Speaker.
Questions and comments. Question et commentaire. There are members for Hamilton, Ancaster, Dundas. Thank you, Mr. Speaker, and I do appreciate the member opposite raising the issue of privacy concerns and the rights of Canadians to maintain access to their data and know that it's secure. However, as has been noted, law enforcement across the country has been overwhelmingly in favor of this bill. Talking to Hamilton Police, the Hamilton Police Association, this is their #1 ask because criminals are using electronic tools to commit crimes and police need the correct tools in their toolbox to stop those crimes from happening and to hold criminals responsible. So would the member opposite agree that it is our obligation as a government to protect Canadians from crime and to support police and law enforcement? Thank you.
For Vancouver East.
Mr. Speaker, as I've noted before, and the government keeps on saying that they got the balance right. If they're so certain about that, why didn't the government ensure the Privacy Commissioner is incorporated in the consultation process with the development of Bill C-22? Why did they deliberately exclude an independent officer that will give Canadians the assurance that they've got the balance right? Perhaps the government can actually bring in an amendment to ensure that that is taking place and to ensure that this doesn't become law until that happens.
Questions and comments. Question commentaire. The member for Winnipeg North.
Thank you, Mr. Speaker. I do believe that there are the checks and balances. The government is looking at the importance of lawful access, sees the benefits in terms of protecting the national interest, national security, things like terrorism. It deals with child exploitation, sexual exploitation. It deals with issues like extortion, all critically important public issues, but it also provides the checks that are necessary to provide assurances that Canadians' privacies are also protected. So it's on both sides. The critical thing for me is looking at it from the point of view, Mr. Speaker, that we have now been waiting for just under a year, a lot of debate about lawful access, and I'm wondering if she could just share the member's own personal opinions as to why it's important that maybe we have a further discussion at the committee stage to make sure that it's done properly.
The honourable member for Vancouver East.
Thank you very much, Mr. Speaker. And to that point, if the government was so sure that they got the balance right, why did they not ensure the Privacy Commissioner provide their views and recommendation on Bill C-22? The government was sent packing on Bill C-2 because of overreach, because of the omnibus bill, because the Canadian public civil society organizations, civil liberties organizations, privacy advocates all said that the bill was wrong and was overreach. The government went back to the drawing board and came back with Bill C-22 on lawful access. But they missed a huge step, making sure the independent officer is incorporated into that consultation process. Why did the government exclude that?
Questions and comments. L'honorable député de l'Abitibi-Témiscamingue.
Merci, Monsieur le Président. J'aimerais entendre ma collègue sur justement les risques de dérapage ou les questions que ça amène pour les gens de la diversité. Est-ce qu'elle craint qu'il pourrait y avoir des formes d'abus qui soient faits par des autorités? Merci, Monsieur le Président.
Honourable member for Vancouver East.
Thank you very much to my colleague for that question. Of course, I'm very concerned that there could be overreach. And because that is an alarm bell that civil liberties organizations and privacy advocates have actually rang to say that this is overreach. They are very worried that instead of targeting a specific act or a specific investigation, this applies to all Canadians across the board as generalized collection of metadata, of retention, of it being kept in place for a year with no specific ties to a potential criminal activity. So those are real concerns. So the government needs to make sure the balance is right, and hence the requirement, in my view, to ensure the Privacy Commissioner's views and recommendations are incorporated into Bill C-22.
Questions and comments. The honourable member for Winnipeg Centre.
Much, Mr. Speaker, and I'd like to thank my honourable colleague from Vancouver East for sounding the alarm on Bill C-22. As she's mentioned, there's many groups civil liberty groups that are speaking out against this bill, like they have done with the majority of Liberal bills that have passed. How urgent is it for the Liberals to amend their bill to make sure that they are upholding the charter rights of people across Canada? Thank you, Mr. Speaker.
Briefly, please, the honourable member for Vancouver East.
Very much, Mr. Speaker. I want to acknowledge and thank my colleague, the member from Winnipeg Centre, because on the issue around surveillance, Indigenous people have had the brunt of it. We just recently learned how there was secret surveillance of Indigenous leaders and Indigenous community members. You know, this is happening right now, and we have now only just learning about it. So as we talk about expanding surveillance activities and capabilities, we absolutely need to make sure all the checks and balances are in place and to ensure our basic charter rights are enshrined in the charter are protected.